My notes from last week just indicate that there was an agreement that Ms. Solinger was going to move out by today's date. We gave her an additional week to do that, to see if that has occurred. Has that happened?
That has not happened, Your Honor. My client is here to talk about she had some health issues, so she has not been able to move out this week. She's still actively looking to move out. My stance is remaining the same. I agreed to a mutual termination agreement so that they could get paid. We did not agree to a writ on the record. So they did not do the jurisdictional prerequisite of giving the VAWA notice that they required to get a writ in this case. So I'd ask that this case be dismissed, Your Honor.
Okay.
Yeah.
From you, Mr. McCree.
That couple interesting things. Ms. Solinger has posted on her Facebook that she's in her third week of being in her new house. She's not in this property anymore. And she claims that she's had less than 1 month to move out when the notice was served on her in November. She's had 5 months at this point to move out. And I think part of why we're even talking about this case right now is because of the court's goodwill notion that we want to preserve Ms. Solinger's money through the housing authority. And here she is working against the people who are trying to help her. My client has to sit on a property that they gave notice they're going to sell clear back in November. And, at some point, her activity has to be counted against her instead of everybody making excuses for it. And that's what's going on the front of the occupancy of this property. She doesn't live there anymore, and she's just wasting everybody's time in that regard. On the other side of this, CR2A is pretty clear. When you reach an agreement in court and you agree to it out by the 20th, that means she agreed to be out by the 20th. She is not out by the 20th, and the correct fallout from that is that we move forward with an order for a writ of restitution. Counsel trying to argue and pull a foot out of the grave by saying, gosh, I can't agree to that. That in this instance, that's nonsense, because we had fulfilled all of the obligations under the Residential Landlord Tenant Act for a notice based on an intent to sell. And
that's not true.
The court could have granted that order on that day, and all of those timelines had run. And so here we are in front of the court after counsel has agreed that she would be out on the 20th. And she's not out on the 20th. So because of counsel's agreement to this, we are now in a position where the court should enter the order for the writ of restitution.
So can you tell the court, in response to the argument from Mr. Kiernan, that essentially, and I know we talked about this briefly last week, the Violence Against Women Act is what the main contention from Ms. Solinger's perspective is, and that your clients didn't comply with essentially providing that notice. And I know last week you'd indicated that there was an agreement, and because of that agreement, essentially she's waiving that right to it. So can you expand on that a little bit as to what your client's position is?
Well, counsel operates on behalf of his client as her legal representative, and counsel committed that she would be out by the 20th as a matter of a Court Rule 2A agreement. That is 180 degrees the opposite of asserting the VAWA notice issue, and that is a knowing and intentional waiver of a known right or relinquishment of a known right. That's the definition of waiver. A CR2A is a CR2A, and there we are on the brink of the court ordering a writ of restitution, and by agreement, she got more time.
So, Your Honor, I do not believe that we did an agreed move out, which I said, which is a device that we can use to help get the housing authority paid for their money. Yes, I said that she would agree to move out. There was no terms as to what the carrot was, what the stick was, that a writ would be issued. The record does not reflect that. If we were going to be saying that a writ could issue when they could not, when they did not have this jurisdiction to be issuing. I think we need to have a knowing waiver of that in written terms. We clearly just did not have an agreement here, Your Honor. They did not do what was required. And again, I was trying to work together to have a settlement to get this landlord paid for February by doing a mutual termination agreement, which means that the parties agree that she has been staying there that long so she can get paid. I just don't think that without a clear relentlessness of that offer to get a writ, they can just get a writ, especially given that we conceded that they didn't do the jurisdictional prerequisite necessary. Again, I was trying to work to get his client paid as part of an agreement, but there was never anything signed. There was never anything there. So again, I just don't think that they did not do the jurisdictional requirement. They did not do the requirement that they needed to end this tenancy correctly. So you cannot issue a writ here, and we did not waive our ability to do that. And if we did, I think that would need to be in writing, and it would need to be very clear, Your Honor.
So, Mr. Kieran, let me ask you, Mr. McCurry indicated that Ms. Solinger is posting on social media that she's out of the residence, but that's not accurate?
She has keys to a new one. She is a single mother, and it's been a challenge to get all of her things out of the house, and she can testify to that. She is here. So she has keys to a new house. She's just working on getting out. She had some health problems come up this week that left her unable to do that. She just does not have a whole lot of help to get out. That being said, I don't think any of this is relevant because, again, they did not issue the Violence Against Women Act that they said that they would do when they terminated the tenancy under the housing choice voucher. So that's really as far as this goes, Your Honor. Again, I was trying to work with tenant or with counsel to get his client paid for that month. It looks like that agreement fell through because they wanted a writ and we were not willing to give that writ. I don't think because we were trying to come to an agreement that ultimately we never did, my client should waive his rights unless that was very clear, Your Honor.
Okay. Okay, so here's what the court is going to do today. I'm not going to give a decision on the docket. I want to look at a couple of things that's going to take me part of the afternoon. And I apologize, parties, for that. I know when I was an attorney, that's a frustrating scenario, but it's important that this decision is correct. And I have reviewed everything from last week. I reviewed the answer and affirmative defense and also the memorandum that Mr. McCurry provided. I want to look specifically at the issue of there was an agreement last week, and the question about CR2As, and CR2As are very specific in that there has to be essentially a meeting of the minds. It doesn't require it to be in writing. Two attorneys have to be present, which we have here. That's the question that legally I need to look at, is by entering that agreement to remove herself from the property, does it waive any of those affirmative defenses? And I can't tell the parties what the decision is going to be, but I will make it today. So I'm going to do a bench order will be completed later on this afternoon after I have a chance to look into that issue. And then I'll send that out to the parties. I had really hoped that when we got here today that we would be getting information that Ms. Solinger had essentially moved out, because as I told the parties last week, she has a high number of children. She is got some health issues. She's trying to move out. The court wanted to give Ms. Solinger an opportunity to protect her voucher, but Mr. McCurry's clients also have rights to this property and have, legal right to say that, hey, we would like it back. And they're starting this action because of that. So the court has to balance all of those and make sure that we're following the law, especially in regards to the agreement, to see if it did waive those protections in the Landlord Tenant Act. So that's what I'm going to do. If there's a need for any further hearings past what the court's decision is, that will be in the order as well. I will email that to the parties this afternoon.
Thank you.
Thank you, Your Honor.
Thank you. Thank you, Ms. Solinger, for being here. Just stay in touch with your attorney so that you can know the next steps once that decision is completed. Okay, next matter.
Properties versus Levi Bondurant 26-2-00168-0208 with Mr. McCreary. And we have a signed order on that one. And Mr. McCreary, my client just dropped off the money, so we'll be dropping that off at your office after court. So we'll do an OLD later today.
I just got a note to that effect, and once I have the money in hand, I will sign the agreement, and I guess we'll just proceed under the agreement from there.
Okay. So the agreement hasn't been officially signed off on yet? Mr. McCurry?
I think we have signatures on all parties. Have you not signed it, Mr. McCreary?
The agreement said that the money was to come contemporaneously with the agreement, but I got the signed agreement from your client. And what happens, Your Honor, is if if we make money a contingency on an agreement and then the money isn't paid, what ends up happening is Justice Project, the defendants have the right to argue that their rights under the Residential Landlord Tenant Act have been compromised in a way that they're not allowed to compromise them, and I can't enforce my agreement. And
Right.
so I have to make the money a precondition to entering into the agreement so that it
Let's just
happens
set this over 1 week
contemporaneously.
then.
No, that's fine. So it sounds like, and folks can correct me if I'm wrong, that the money is working on being changed hands, and we just have to wait till Mr. McCurry's office gets that, and then once that's completed, then the agreement will be.
Yeah, I think we can do everything
signed.
else ex parte at that point.
Okay. Yeah.
Yes.
That, I think that sounds like a good plan. And the case I did.
I'm not worried because I have the money in hand in my office,
Okay.
so there shouldn't be too many. That being said,
I did see
surprises always happen.
This case is set for a trial the week of March 30th. So that's what we were here for today, just to check in on if there was a payment plan or if the parties could work out agreement, which it sounds like they did. So thank you everyone for doing that. What I would ask is that once Mr. McCurry, you receive those funds, if you want to sign off on the order and just send it ex parte, I can sign off on it and we can get it filed from there.
Okay.
Okay.
Sounds great.
Thank you, Mr. Bondurant, for being here as well and for working with your attorney to accomplish that agreement. The next hearing that we have, it's on for a readiness hearing on March 24th at 11:30 a.m. to determine how we can proceed if the case is proceeding to trial.
I'm assuming we'll just be striking it there, Mr. McCurry.
Yeah. I mean, I assume there's certified funds on their way.
Yes, yes.
Okay.
Okay.
And Your Honor, I apologize for the little speech there, but it's a real factor in dealing with these things that the way the Landlord Tenant Act is set up, Mr. Kiernan can enter into an agreement with me that he can later say, well, technically I can't enter into that agreement because it compromised their rights under the Landlord Tenant Act. And that has happened once before, and I'm just trying to guard against
Preview
that.
for a case coming up, I take it.
Yeah. No, I do appreciate that. And I think folks know that my practice was not in unlawful detainers. So I think the more information that can be provided to the court, the better. It just helps to overall grasp all the intricacies of the landlord resident tenant actions.
I hope my memorandums on rent cases have proven to be fun to read.
Yeah, they're actually really helpful. Okay, thank you, Mr.
I think
Bondurant.
those are all the easy ones.
Okay.
I think Mr. Nelson has a couple for.
Okay.
All right. Nona Dixon, I think I emailed you the service on that. She was served on the 13th, so that would be 7 days before today. But the court does not have this, I'm sure. She sent me a response.
Oh, okay.
So I'm going to read it to you. It's one paragraph. To whom it may concern, this is Nona Dixon, and I am responding to your eviction summons. I am asking for a little time as I am looking for a place to live and trying to obtain an attorney. Also, I do not see a court date on the summons. Well, there is no court date on the summons. It's on the order to show cause, which she was served with.
Okay.
If nobody's in your waiting room or on Zoom, then she's not with us today. I guess my position would be I'd like a writ issued today. I'm willing to stay it for 2 weeks to give her time to move out. But that would avoid me having to come back to court.
Does the letter that Ms. Dixon provided to you, does it have a date on it?
She did not date it. We got it by fax yesterday. On the fax transmittal, it says 3/19/26.
Okay. Let me check in. Is Nona Dixon present in the Zoom call? Other than Ms. Dixon indicating that she's working on getting an attorney, is that the only sentence about that?
Oh, she's asking for more time because she's looking for a place to live
Okay.
and trying to obtain an attorney.
Okay. I'm gonna look at one thing and then I'll get back with you. Are you, aside from asking for a writ today, are you asking for the judgment and back rent payments?
I do not ask for money judgment at this hearing.
Okay.
There should be an order that I provided.
Yeah, we do have it.
And if you're inclined to grant it on those terms, you could write in that it's execution is stayed until April 3rd, which
Okay.
means we wouldn't contact the sheriff until the next week.
I think all of that sounds appropriate. While I appreciate that Ms. Dixon did provide you with a notice, there are legal aspects that she did not comply with. She didn't file a notice of appearance. She didn't file anything that the court can review, and couple that with her lack of presence today, the court can legally sign the writ because it is appropriate. I appreciate that we would give Ms. Dixon the opportunity to stay it until, what was the date again?
April 3rd, it'd be 2 weeks from today.
Okay. So I'm gonna add, if I add that as an asterisk on the writ, is that any objection to that?
I don't think that will be a problem.
Okay. Okay, so I added to the order that the writ shall be stayed until 4/3 of 2026 to allow the defendant the opportunity to move out of the residence.
Okay.
Okay,
All right. Thank you, Your Honor. That's all.
thank you. I think that takes us to the end of our docket.
Okay. Have a
Thank you,
good day.
everyone. Have a good day.